Thank you very much indeed for that very warm introduction. I was about to say it was a long introduction as well, but I won't. It's my great pleasure to be here with you this afternoon and to share some thoughts about universal access to information. I should say, first of all, that when I got the invitation from the Media Institute of the Caribbean and from UNESCO, I knew nothing at all about the Universal Access to Information Day. But I was intrigued by the invitation for two main reasons. The first is that when I was a boy growing up in Jamaica, in rural Jamaica, the task of obtaining a birth certificate from the records office in Spanish Town was an ordeal. It really was. You had to start planning from the night before. You then had to make sure, of course, you got transportation into Kingston, into Spanish Town. There was a sea of people there. And very often, of course, you were encouraged to um, pay some money to somebody who might be able to expedite the process somewhat. And then very often you would stay until the end of the day and not get what you went for. So you had, of course, to go back again on another occasion. It was really, as I said, an ordeal. And therefore, the idea of easier access to information is something which, of course, accords very happily with me. The second reason I was happy to participate is because it seems to me that this whole notion of access to information is tied up with a concept I've been struggling with for a little while now, I've been working with, and that's the concept of personal autonomy. The notion that individuals are, as Kant said, ends in themselves and not mere means to an end. And it's therefore important that if individuals are going to exercise autonomy, are going to exercise agency, they must have information available to them by which they can do that. So I was very, very pleased to accept the invitation. I hope I don't overstay my welcome. I have some slides prepared for you. And I wanted to just indicate the manner in which the presentation will unfold. I will look at the regime of access as dictated by legislation. I will then talk a little bit more about this principle of autonomy, which to my mind is central and key. Thirdly, I'll speak about some of the challenges to universal access to information in the Caribbean. And finally, very briefly, I just mentioned some of the special challenges that arise in times of crisis. So as many of us would be aware, there is a regime in place in many of our jurisdictions, and it's in place by virtue of legislation. There's an act, often it is called the Freedom of Information Act, or the FOIA. And that legislation has certain features. And to my mind, there are 6 features which we should mention very briefly at the start of the presentation. The first feature is that there is a statement of the objective of the legislation. So in the example I have here, it says that the objects of this act are to reinforce and give further effect to certain fundamental principles underlying the system of constitutional democracy, namely government accountability, transparency, and public participation in decision making. The second feature is the prescription of a general right of access to information. And again, in the example I have here, The statement, which is relevant, is subject to the provisions of this act. Every person shall have a right to obtain access to an official document other than an exempt document. Now you notice that there's a slight switch from information to document, but of course, normally the document has the information that you require. An interesting question is whether if the information is housed in some other form. In a video, for example, does this suggest that there is a restriction on the right to access that piece of information? We'll come to that in due course. The third feature of the legislation is that there is a procedure for making the request. So the applicant for the information fills out an application form, perhaps. That application is normally in writing. And again, of course, we're moving away these days from writing on hard paper, but again, we'll come back to that. The information that is provided must be sufficient to identify the document that is being requested. So that's the procedure by which the request is made. Fourthly, there is an obligation on the government, let us say for the time being, to respond within a specific time. Normally, the legislation provides for a response as soon as possible, but not later than 30 days, usually. Fifth feature is that the public authority must state the decision to the applicant. So if the public authority, shorthand we say the government, refuses to give access, then it must give reasons. And the giving of reasons, of course, is very important because it is critical to satisfy the applicant that his or her request was refused for good and sufficient cause. So one must give good reasons. That's part of the whole notion of good governance. And also, the notion of giving reasons is important because it assists with judicial review. If the public authority grants access, then of course there must be a reasonable opportunity to actually obtain the information. So the applicant for the information must be allowed to inspect the document, might be able to obtain a copy, photocopy, might be able to obtain pictures, videos, and audio recording. And finally, final feature is the institutional arrangements for review. So there is a decision to be made by the public authority as to whether access ought to be granted to the information. But that decision can then be the subject of review by other persons in the quote unquote command chain, if you will. Person might be an ombudsman, as in Belize, Trinidad, and eventually the matter goes up for judicial review if the applicant is not satisfied with the response to the request. So that is the basic outline of the regime that exists in the region. And I have this slide up to show you that there are many jurisdictions in the Caribbean that do in fact have that basic regime. They differ in some nuances from country to country, but essentially the regime is what I pointed out to you earlier. So you'll see here that we have legislation in Belize, in Trinidad and Tobago, in Jamaica, St. Vincent and the Grenadines, Antigua and Barbuda, Cayman Islands, Guyana, the Bahamas, and St. Kitts and Nevis. One of the interesting things to note immediately is that these pieces of legislation are of recent vintage. The first legislation was enacted in Belize. And that statute in Belize is not just the first in the Caribbean, but I'm sure Dr. Sanchez would be happy to hear it was the first in the area of Latin America and the Caribbean. So freedom of legislation, sometimes called Access to Information Acts, started in the mid-1990s, and we have a fairly good record of adopting these statutes throughout the region. But immediately there are some features which arise. The first is that obviously we don't have legislation in all of our countries. So my information is that we have draft acts in Barbados, in Dominica, and in St. Lucia. And I'm not altogether clear what the situation is in relation to Grenada. Notice also that there are sometimes differences in relation to how the legislation is drafted. So in the earlier statutes, such as in Belize, for example, the legislation, it could be said, is drafted in a fairly restrictive way. The application must be made in writing, for example, whereas in later statutes, such as in Jamaica, the application can be made in writing, or it can be made over the telephone, or by other electronic means. So there are some differences in the legislation. And again, even though we have them all listed on the screen there, the fact is that they're not all equally effective. For example, the legislation in Trinidad and Tobago, where I'm now located, is very actively used. There are many, many applications, but that's in, for example, the Bahamas. Even though it has been passed, it has not yet been brought into force. So there are lots of differences between the various pieces of legislation and between and among the various jurisdictions. Just to underscore the point about the prevalence of activity under the Act in Trinidad, I have a couple of screens here which show you some of the cases decided under the FOIA of Trinidad and Tobago. Ridgelal against the Commissioner of Police, I may say something about that a little later. Number 12, Balroop against Public Service Commission, 2005. I highlight that because I think that might have been, as far as my research goes, the first case to have been decided under the FOIA in Trinidad. Then there are these other cases. Number 18 is highlighted because, again, as far as my research goes, that could have been the most recent case decided under this statute. And I might mention Jug Mohan against the Teaching Commission later on. So that is it then. We have, as I said, quite a number of statutes, not yet universal, and that is something I think that we must agitate for in terms of encouraging our governments to adopt legislation. As I said earlier, I'm intrigued by this notion of universal access to information because I believe that it is really an expression of something much more fundamental, and that is the principle of autonomy, or if you prefer, personal autonomy. And that notion of autonomy, of self-governance, of agency for the individual goes back to ancient times. But I think in modern times, it is most closely associated with Immanuel Kant, a controversial figure, admittedly, in some regards. But Kant spoke about certain imperatives, which he called categorical imperatives. And he arranged these imperatives. I think there were 3 in all, but we need to just mention 2 this afternoon. The first imperative was that one should act only according to that maxim, whereby you can at the same time will that it should become a universal law. So one conducts an act only if one is convinced that that act could in fact be universalized and be acted upon, be performed without harm to the community by all members of the society. The second maxim was to act in such a way that you treat humanity, whether in your own person or in the person of any other, never merely as a means to an end, but always at the same time as an end. And the idea here is that, as it said in the good book, in effect, do unto others as you would like them to do unto you. Do not treat people as mere means to an end. So if the plumber comes to your house to fix the faucet, and for some reason you try to wiggle out of paying for the service, or if the mechanic fixes your car and for some reason you try to wiggle out of paying for that service, the suggestion is that you're using those persons simply as means towards your end. And Kant's categorical imperative is that we should do that. We should always treat people not merely as a means to an end, but as ends in and of themselves. And this means, I think, that he's suggesting that the human person is worthy of dignity, is worthy of respect, and is worthy of regard. Now, I believe that his philosophy had a very important impact on the revolutions which took place in Europe and in the United States in the 18th century. And if you read the Declaration of Independence of the United States, speaking about the right of the individual to life, liberty, and the pursuit of happiness. And if you read the Constitution, if you read the Declaration of the Rights of Man and of the Citizen, 1789 of France, and the first Haitian Constitution, and in Haiti as well, the Constitution speaks about as well the right to life, liberty, and the pursuit of happiness. Also, of course, give me liberty or give me death. The whole notion here, to my mind, is underpinning the concept that human beings are worthy of dignity, worthy of self-governance. I also believe that modern human rights developments underscore this fundamental point. So if we look, for example, at the United Nations Universal Declaration of Human Rights, 1948, and the European Convention on Human Rights, 1950, the European Convention simply enforced, made applicable many of the principles in the Universal Declaration of Human Rights. In our own constitutions in the Caribbean, based on the Westminster model, there is a Bill of Rights, and that Bill of Rights tends to reflect a lot of what is in the European Convention of Human Rights, 1950. And of course, some of us have a Charter of Rights and Freedoms. To my mind, this notion of autonomy is at the root of access to private information. Now, access to private information is not governed by the FOIA I mentioned earlier, not required by law, but very often it is the linchpin of transactions which take place between members of the society. So in the medical field, for example, we're all familiar with the requirement for informed consent. And that is to say that the doctor must give the patient all the information that is relevant, and the patient then makes a decision about whether to accept treatment or not. So the patient really can refuse treatment even if that results in death. And the reason for that is that the patient has bodily integrity, has autonomy, and must obviously make these critical decisions for himself or herself. The notion of informed consent, of course, transcends just the medical field. We are doing a case, we meaning the CCJ, are monitoring a case from Belize, in which a decision was given to respect the rights of the Mayan people to live on their traditional lands. These lands are to remain undisturbed by commercial developers, except when these commercial developers come to the Mayan people and obtain their permission to engage in some degree of development. But that permission is based on prior informed consent of the Mayan people. So the developer must give all the relevant information so that the Mayan people can in fact make informed decisions as to whether to allow development. But I think nowhere is this notion of access to private information more vividly illustrated than in relation to technology and the provision of services to the individual. There is a beautiful story of this gentleman, I think his name was Richard Barton, the founder of Expedia. He makes the point that he, in his job, was concerned about traveling from place to place and so on. So he called up his travel agent and indicate that he wanted to travel from A to B, stopping at D. And he'd have the phone to his ear and he'd listen to the travel agent on the keyboard trying to put him in touch with the best, best flights, best hotels, and so on. And he had the idea that it would be so wonderful if he could remove the middle person from the consumer of the service and the provider of the service. And therefore he created the Expedia model, which of course was and is very highly successful. He makes the point that in this day and age, barriers between technology and the providers of services are just completely unsustainable in the age in which we live. So today, of course, you can, well, not right now, but when we don't have the restrictions imposed by COVID, you can, of course, go and choose your aircraft, the kind of equipment you wish to fly on. You can choose the seat in which you want to sit. You want a window seat or a middle seat. When you get to where you're going and you land, you can choose your Uber. The information there is empowering because it allows the individual to make choices based on their desires. Now, it is my suggestion to you that the whole regime of access to public information is also based on the same basic idea of autonomy, of agency, of allowing the individual to choose for himself or herself. One indication of that is a provision in the Constitution which speaks to the freedom of expression, the right of freedom of expression. And that freedom includes the freedom to receive information without interference. So that's a fundamental constitutional right that we have, the right of receiving information so that we can freely then express our points of view. Autonomy also underlies, in my view, many of the international documents on access to information. There is the Aarhus Convention of 1998, the Escazú Agreement of 2018. These deal with access to environmental information. There is a convention in Europe, the Council of Europe Convention on Access to Official Documents, adopted 2018, entered into force January this year. And if you look at the survey done by Mauve McDonough, when the person there writes about right information in international human rights law, you will see clearly that the view is that all of these international legal instruments are based on fundamental right to expression, right to privacy, right to fair hearing, and so on. In our jurisdictions as well, in one of the cases I listed earlier, I don't have time to read the actual quotation, but you'll see that Justice Gobind there spoke about the legislature in our jurisdictions giving right of access to information and empowering ordinary citizens. So, what are the challenges then to universal access to information? What are the challenges that impinge upon the ability to enjoy the requirements of agency, the requirements of autonomy? The first couple of points I've already made, and that is that in some jurisdictions, the FOIA is not very effective, very active. Maybe because there is no statute. It may be because there are just draft bills at the moment. It may be because the statute has been passed but not yet brought into force. It may be because of some other systemic issue. But the fact is that not all of our jurisdictions are enjoying the benefit of universal access as prescribed by legislation. Second point I've already made as well, there is sometimes inconsistency in the use of modern concepts. Not all of the legislation employ the most up-to-date concepts which are critical to the right to access information. The issue of model legislation is something that perhaps could be discussed. Thirdly, then, the question of public information and how do we define public information? And that can be problematic because public information in the legislation is normally defined as information held by public authorities. And then public authorities are defined basically as the government, including central and local government where it exists, statutory bodies, government companies, companies in which government owns the decisive influence, 51% shareholders, etc. But the fact of the matter is that there are many instances where the services provided by an entity are critical to the well-being of the members of the society. So that even though the entity is a private sector entity, it would be useful if that entity was subject to the rigors and the demands of the FOIA. I loved how it was put in one study. It was said that for most citizens, it does not matter whether the government is responsible for their electricity supply or a private entity. What is of concern is that it is accessible, consistent, and affordable. So the point then is that we have to, as media practitioners, have a look at our situation. Is there an entity providing an essential service to the public? And if it is, and particularly if it is enjoying a monopoly, it seems to me that that entity ought to come under the purview of the FOIA. There is a provision in the legislation, you'll be happy to hear, which allows the relevant minister to extend the reach of the legislation to include entities other than those in government. But that procedure is subject to the affirmative vote in the Parliament. It must be approved by an affirmative resolution, and therefore the extension will require advocacy and argument by those who are interested in that. Next issue has to do with records management. This is a major problem. In the old days, of course, when I was going into Spanish Town to collect my birth certificate, the records management procedure was abysmal. It was terrible because, you know, there was no proper record keeping. I was reliably informed afterwards. Obsolete files, dormant files would be shelved with current files. There was no institutionalized system modern system of record keeping. Now, with the passage of the FOIA, or Access to Information Acts, that has been dealt with significantly because public authorities have been required to institute effective records management procedures. So that is in place. However, the critical question then is there the ongoing training? You know, is there the ongoing capacity strengthening that is needed to support the regime of records management? Another difficulty, another challenge has to do with exempt documents. And there is a very, very long list of exempt documents. I'm not going to go into this because I'm very sure somebody will mention this later in the panel discussion. But the fact of the matter is that if you were to look at the list of documents, you get very concerned about if there are any other documents left which must be disclosed. Documents relating to national security, cabinet documents, documents relating to law enforcement, national economy, documents relating to heritage sites. All of these documents are exempt documents, which means that they need not be disclosed by the public authority. Now, to my mind, that is a very, very difficult area and one which must be looked at very, very closely. There is a provision in the statute usually that where the minister gives a certificate that the document is exempt, then that makes for conclusive evidence that the document is in fact exempt. Now, there are, as I said, difficulty because the list is so very long. Note, however, that there is a case from the United Kingdom. It's called Kennedy against the Charity Commission, 2014, 16 years ago, 6 years ago. And in Kennedy against the Charity Commission, it was held by the UK Supreme Court that there is a common law right of access to information. So that even though an exemption applied, document was exempted under the legislation, the applicant there, a journalist, could still rely upon the common law right of access. It's a difficult case because, of course, the situation in the UK is different and the wording is different. The European Convention is also relevant there, but it's nonetheless, I think, important for us to have a look at to see the extent to which there can be a common law right of access. And the other point to make is that in at least one country, Trinidad and Tobago, the exemption is not absolute. So the exemption is subject to a public interest test. That is to say that when it comes to the court eventually, the court has to decide whether the public interest in disclosing the information outweighs the public interest in keeping it secret. And there are so many cases which, in fact, have been decided on this point. Cumberbatch against the Minister of National Security is one of those cases. In that case, the applicant for information wanted to get his hands on a financial record to understand how it is that $2 million of taxpayers' money had been used to support a celebratory event. And he was denied access to the document on the basis that it was a cabinet document. On judicial review, it was held that this document had no, national secrets, and it could and should have been disclosed. I'm virtually out of time, so I'll go very, very quickly to just mention human resources. That can also be a challenge in terms of having enough competent persons to man the desk that makes for disclosure of information. The absence of penalties as well, where the agency does not provide information, there is no penalty that is imposable on that agency. Cost is not normally a factor. There's no cost attached to the actual work in getting the information out, but there is a cost for the copying if that is necessary. and that can be an element to be considered. Finally, very briefly, the special challenges posed to this regime of universal access in times of crisis. The first point is that there needs to be urgency, of course. The applicant needs to get information urgently so as to be able to exercise autonomy. But the problem is that certainly in the event of COVID, the public sector employees can't go into the office to generate the information if they need to go into the office. They can't go there to consult their files, etc. So what has happened in some jurisdictions, for example, in the United Kingdom, is that there's legislation which really pushes back the time period within which the public authority must make disclosure. And that, of course, is counterintuitive in the sense that we do need information urgently given the situation in which we are, but that is countermanded in some sense by virtue of the difficulty of providing that information in a timely way. Many of our Freedom of Information Acts provide for the relevant agency to put as much information as possible in the public domain. There's a right to know. And I must say that in the current circumstance, many of our governments have been using the television and internet to get out the message about the COVID-19 pandemic. In Trinidad and Tobago, for example, there is a virtual press conference virtually every day, perhaps every other day. And I'm pretty sure that something similar is happening in most of our other jurisdictions as well. And that I think is a very good thing. Generation and verification. I think it's very, very important that the information be truthful. The chair, as she started this afternoon, mentioned the notion of truth, so that we have to make sure that the information is available, but that it is also truthful. There's no obligation at the moment on the government to generate information. The obligation is to give access to the information in the government's possession. But query whether there ought not to be an obligation as well to generate that information. And then, of course, to verify that information is useful. You'll know, of course, that in Florida, I think a day or two ago, the governor there lifted all restrictions, all the COVID restrictions. So social distancing, wearing of masks, going to restaurants indoors and so on. All of those things have been lifted by the governor in Florida. And he has done that on the basis, he says, of scientific advice, scientific information. So the question is, how valid is that? Do our governments get that information? Do they evaluate and pass it on to the public? And finally, of course, even in the midst of a crisis, and indeed, especially in the midst of a crisis, it is necessary that our constitutional rights are respected. There are many instances in Trinidad here over the recent times where there have been issues about whether the police can exercise certain law enforcement functions, whether these functions would impinge on constitutional rights to privacy and so on. I don't intend to enter into that debate, but the point is that even in these times of crises, these trying times, it's very important that all of us, and in particular, I think the media industry, makes sure that our constitutional rights are recognized and are respected. And with that, I thank you very much for listening, and I wish you a very successful meeting. Thank you.